And then are we hiding the non-video participants?
That is correct. Yes. So you currently have some that are showing their video. Once you enter the room, I believe that's what they were trying to do. They will all shut off their videos when they are not participating.
Very well.
And our YouTube is up and running. You are more than welcome to start whenever you're ready.
Absolutely. So my name is Judge Corkadell. I'll be presiding over this case today. Is the prosecution ready to proceed?
Yes, Your Honor.
And is the defense ready to proceed?
Yes, Your Honor.
The scoring panelist, as well as myself, have already been provided with the roster, so we don't need to worry about that. We do understand that the Colorado Bar Association is recording these programs and that your participation in this allows for photography as well as video clips to be used for any purpose. Just want to make sure everyone's aware of that. And at this point, is there anyone in the gallery who is not competing in this round? No, looks great. Do any of the scoring panelists have any reason to be concerned about judging the people that you see on the screen? No, looks good. Can I have the prosecution please introduce the members of the prosecutorial team?
Yes, Your Honor. Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Emma Senishin. My co-counsel and I represent the prosecution in today's case. If my co-counsel could go ahead and introduce themselves.
Good afternoon. My name is Alexandra May.
Good afternoon. My name is
And Ms. Humber, I apologize, your audio connection's a little bit suspect. We'll give you a moment just to make sure that works. I want to make sure you can be involved.
Lily, on your microphone icon, there's that small up arrow. You might just have to reselect your microphone.
Did that work?
Perfect.
It sure did.
Perfect. Thank you so much for letting me know.
Not a problem.
May our
And then
witnesses
for the
introduce
defense,
themselves?
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Tessa Awald, and I will be conducting the direct examination of Avery Becker and the cross-examination of Kyle Kuzak.
Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Leah Farrell, and I will be conducting the cross-examination of Jordan Markowitz, the direct examination of Taylor Perkins, and I will be delivering the closing statement on behalf of the defendant.
Good afternoon, Your Honor, opposing counsel, and members of the jury. My name is Elena Medina, and I will be conducting the direct examination of Blake Van Owen, the cross-examination of Alex Cifuentes, as well as delivering the opening statement on behalf of the defense. At this time, your witnesses introduce themselves.
please.
Good morning, Your Honor, and members of the jury. My name is Zahidi Balaji, but today I am Avery Becker.
Good afternoon, counsel, members of the jury, and opposing counsel. I am CJ Geisbert, and I am Taylor Perkins.
Good morning, Your Honor, opposing counsel. My name is Kayla Anderson, but today I am Blake Van Owen.
Does that conclude our witnesses? In that case, I will go ahead and ask all the team members to please raise your right hands. And do you all promise that the presentation you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial competition? And witnesses, do you promise that the testimony you're about to give will faithfully and truthfully conform to the witness statements, that you will not add material facts or opinions which are not contained in the case problem, and that you will follow the rules and procedures of the mock trial competition? Gallery members, including teacher and attorney coaches, family members and friends, please raise your right hands. Do you promise to represent yourselves as positive role models and to behave in a manner that exemplifies ethical and professional sportsmanship during and after this mock trial round. And lastly, for scoring panelists, would you please raise your right hands? Do you promise to adjudicate the mock trial competitions as fairly and objectively as possible in accordance with the facts, procedures, and rules of the mock trial competition? Thank you. Are there any preliminary matters that we need to address prior to continuing with the prosecution's case?
Yes, Your Honor. Permission for our witnesses to introduce themselves.
You may.
Good afternoon. My name is Lola Fakes, and I am Alex Fuentes.
Good afternoon. My name is Carolyn Johnson, and I am Kyle Kuzak.
Good afternoon, Your Honor. My name is Tess Hayden, and I am Jordan Markowitz.
Thank you.
Your Honor, we have 3 housekeeping matters in addition at this time.
Very well.
First,
and I will, if I may, just very briefly, I'd ask that anybody who is not participating in the active portion of this trial, just turn off your video. It will also help unclutter the presentation for people watching online and give our scoring jurors a little bit of privacy.
Thank you, Your Honor.
Very well, please continue.
First, we request permission to reserve any time not used in our closing argument for a rebuttal.
Very well.
Second, there are stipulated facts that have been agreed to before the trial today. We request that these facts are constructively read into the record.
Also agreed to, as long as the defense has no objection to those stipulations.
No objections, Your Honor.
Thank you.
Finally, when we enter exhibits during the trial today, we intend to screen share the exhibit at the onset of the questioning of the witness. We would then proceed with entering the exhibit. In this case, the jury would not constructively see the exhibit until Your Honor has formally admitted it. Would this be acceptable, Your Honor?
It is the way that our Zoom courts are handling things, yes.
Your Honor, we have no further housekeeping matters at this time. Thank you.
Any housekeeping matters from the defense?
Yes, Your Honor. The defense requests that due to the virtual setting, lawyers may remain sitting for direct and cross-examinations as well as objections.
Granted.
On sustained objections, would you like us to request that testimony is stricken from the record, or should we assume that testimony has already been stricken?
I'll have a standing order that testimony will be stricken if it is a sustained objection.
All right, and Your Honor, we would ask that our timekeepers be allowed to stop time in the event of technical difficulties.
I think that that's fair, though if we have an extended stoppage, we will address that at that time.
All right, no further preliminary matters, Your Honor.
In that case, we'll move on to the prosecution's opening statement.
Permission to proceed, Your Honor?
Granted.
Mischief was intended, in murder it ended. Good afternoon, Your Honor, members of the jury and opposing counsel. My name is Alexandra May, and along with my co-counsel, Ms. Emma Senishin and Ms. Lillian Humber, we represent the state of Colorado. We are here today to provide the story of March 6th, 2020, the day that Mr. Mackenzie Brackman's life was taken far too soon. Mr. Brackman was a high school mock trial coach at Colorado High School, volunteering his time to allow children to continue their love and growth in mock trial. Let me tell you a story, the story of Miss Avery Becker. It's 3 o'clock on a Thursday, and Avery has just gotten home from school. She storms into the kitchen in a fury, and in a rage, she throws her backpack to the ground. You see, after practicing for hours and competing and winning many mock trial competitions, her coach, Mr. Brackman, continues to belittle her efforts. Their tension is growing, and their fighting is getting worse. So much so that Miss Becker takes a Sharpie marker, vandalizes Mr. Brackman's car by writing "Worst Attorney Award" in bold black letters. But this isn't enough. As she hides away the Sharpie, she pulls out her phone, texting her friend Alex, giving her intent to vandalize Mr. Brackman's home and belongings. Avery's mom enters the kitchen to ask what's wrong, to which the defendant responds, "I will get back at him. if it is the last thing I do. The defense will call 3 witnesses to the stand today. Mr. Taylor Perkins, the defendant's best friend, will show you how incredibly loyal he is to the defendant and has done countless things to benefit the defendant, including quitting mock trial. Mr. Perkins is also Ms. Becker's only alibi for this day. What else is he willing to do for the defendant? They will call Blake Van Owens to the stand, who quit the job in a field directly relating to the field that they are testifying in today. And last, they will call the defendant herself to the stand, Miss Avery Becker. This isn't Miss Becker's first time on the stand. You see, she does mock trial and is great at swaying the jury in her roles as a witness. Miss Becker was absent from school the day of the murder, and Miss Becker's cell phone was placed pinging off of a cell phone tower that is in direct relation to Mr. Mackenzie Brackman's house. The defense will also call 3 witnesses to the stand today. The prosecution will also call 3 witnesses to the stand today, who will prove to you that mischief was intended, but in murder, it ended. First, we will call Miss Alex Fuentes to the stand, a friend of Miss Becker's, who will testify to their great relationship along with the increasing and horrible tension between the defendant and Mr. Brackman. We will call Miss Kyle Kuzak to the stand, an expert in crime scene reconstruction, who conducted a meticulous investigation, put together a timeline for the events of this day that placed the defendant of the same height and build as Miss Avery Becker intruding into Mr. Brackman's house and then proceeding to fatally stab him. And last, we will call Detective Jordan Markowitz to the stand, who is an expert in cell tower data analysis, whose analysis placed the phone of the defendant, Miss Avery Becker, at Mr. Brackman's house. Your Honor, members of the jury, the prosecution holds the entire burden of proof today, but we will provide mountains of evidence. So you will see that the defendant, Miss Avery Becker, is guilty of burglary in the 2nd degree of a dwelling and murder in the 1st degree. At the end of the trial today, my co-counsel, Ms. Lillian Humber, will summarize the facts presented to you. And you will see that you need to make a ruling in favor of the people of Colorado. Your Honor, members of the jury, as the trial is presented to you today, I ask you to keep a simple phrase in mind. Mischief was intended, in murder, it ended. Thank you.
Would the defense like to make an opening statement?
Yes, Your Honor. Before I begin, I would like to request that the court can all see and hear me clearly.
We can.
Thank you. May I begin?
You may.
May it please the court, counsel, and members of the jury. Today's story is centered around a sloppy investigation, selective evidence, and a circumstantial case. Now, Miss May has attempted to paint the narrative of a robbery gone wrong and of a girl gone mad. But when we take a closer look, we will find that the prosecution had decided who is guilty before the investigation had even begun. The witnesses of the prosecution failed to follow through on the multiple possibilities of this case, pinning the blame on a vulnerable girl instead of giving a man justice. Today, you will hear from Avery Becker, a young girl being wrongfully accused of murdering her mock trial coach. Avery is a natural-born leader who uses her skills to her advantage. She excelled in mock trial and brought her team great lengths. Unfortunately, her team didn't always see eye to eye with her, which resulted in some tensions between members as well as her coach. But that tension was a result of team frustration, as we can all recall a classmate or teacher that we never seemed to get along with. That kind of teen angst is nowhere near enough to drive someone to murder, especially someone with so much potential like Avery. Yet, despite this, some of them are now trying to pin the blame of this tragic murder on her, due to the petty drama of a high school club. Today, Avery will tell you about the course of events leading up to Mr. Brackman's murder, her relationships with those on the team, as well as her story, and how she is not the one to blame for this tragedy. You will also hear from Taylor Perkins, a close friend of Avery's and a member of the mock trial team as well. Taylor was a part of the mock trial team as a fun way to pass the time, like many other kids his age. He was often around the team and saw how relationships progressed as time went on, as well as how they could affect the case today. Today, he will tell you about his perception of this case, any information he has to bring his coach justice, as well as both his and Avery's placement during the murder. He will tell you that both he and Avery were together throughout the entirety of the murder, meaning that there is no way that Avery could have committed this crime. However, if that's not enough for you, the prosecution's very own Detective Jordan Markowitz will prove this to you through their cell tower investigation, further showing that the prosecution's claim has nothing to fall back on. The prosecution has tried to tell you that all evidence points to Avery Becker, and this is simply not the case. You will hear from Professor Blake Van Owen, a private investigator and expert witness in police practices, forensics, and crime scene reconstruction. Today, she will show you through her investigative work that the prosecution's investigation not only has flaws beyond conclusion, but how the only way they could have come to this conclusion is through their own clouded judgment and assumptions. Their evidence doesn't point to any specific person at all, let alone Avery. In today's trial, she will highlight the rushed nature of the investigation, as well as how the prosecution failed to look into the multiple possibilities of this case, such as Blair Rollins, whose father had sworn revenge against Brackman before going to jail, who was not in school at the time of the murder, and who has disappeared without a trace since the murder. But did the prosecution look into this very alarming lead? Not at all. Professor Van Owen will show that the prosecution immediately focused solely on Avery Becker and did not even bother to look into other obvious suspects or answer other obvious questions. Was this an unknown burglar who acted rashly? They don't know. Did Avery accidentally kill her mock trial coach? They don't know. Did Alex Cifuentes, the person who resented Avery the most for her success, set her up to take the fall? They don't know. Or did Blair Rollins need a cover for revenge? They don't know. So many possibilities, and yet only one of them explored. Now, today, the burden of proof has been placed upon the prosecution, and they will not be able to prove anything to you. The evidence will show that they had failed to find the true culprit of Mr. Brackman's murder because they made no real effort to do so. The investigation was sloppy, the evidence so selective, and the case is circumstantial. The prosecution had many chances to bring Mr. Brackman justice, and instead, they are willing to send one of his best students to jail for a crime she did not commit, just so they can have an easy way out. One life has already been taken from the Colorado community, and we cannot allow the prosecution to so selfishly take another. And that's why at the end of this trial, we ask that you rule in favor of the defendant and declare Avery Becker not guilty. Thank you.
Thank you, counsel. The prosecution may call their first witness.
Thank you, Your Honor. The prosecution calls Ms. Alex Cifuentes to the stand.
You may proceed.
Thank you, Your Honor. Good afternoon. Could you please introduce yourself to the jury?
Yes, my name is Alex Cifuentes, Sifuentes.
Alex, where do you go to school?
I'm a senior at Colorado High School. Go Eagles.
CHS, okay. What kind of activities are you involved in?
Well, I recently joined the Ping Pong Amateurs Club, but my favorite and certainly most time-consuming activity is mock trial.
Could you tell the jury a little bit about your involvement in mock trial?
Yeah, so I'm an attorney. I've done it all 4 years. It's basically like a fake court case where you have fake attorneys and witnesses, and I'm usually an attorney, and I love it. I always awaited the day that our coach would put out the roles and I'd go home and dig right into the case.
Okay, and do you see anyone here today who did mock trial with you?
I believe I saw Taylor Perkins and Avery Becker.
Were you friends with the defendant?
No, I was not friends with Avery. Or, sorry, I was friends with Avery. Sorry, I got confused there. Yes, we were very good friends. We did mock trial all 4 years together, or all 3 years together. She's a grade above me, or he's a grade above me. He even introduced me to mock trial in the first place.
And could you tell the jury a little what the defendant was like on the team?
Yes. So he was really, really good at mock trial. He was a witness, really, really unbelievable on the stand, really, really convincing. She was like a natural actress. She could sway the jury any way that she needed to.
I see. And how was her relationship with the coach from your perspective?
Not very good. She just would refute what our coach would say. She would refute his advice. He was a criminal defense attorney. It was his job. It's what he did for a living. And she just kind of ignored his edits. One time she showed up to practice really, really unprepared. And she ended up getting demoted to B team for that.
Did she react in any way to this demotion?
Oh yeah, she completely threw a fit. But at that point, if A team had lost another person, we weren't going to be able to go to state. So her really, really good friend, Taylor Perkins, he quit the team. And so she had to be let back on, but she wasn't on there for a lot longer.
Well, how come she was off the team again?
Well, at regionals, she had won a bunch of awards, but she kind of flew off the script, kind of was making stuff up on the spot. And Coach Brackman got on her about, making stuff up, and that, you can't just show up in court and go off the script and expect your client to be acquitted. That would be malpractice in the real world. And Avery left practice fuming with a Sharpie.
And what did she do with the Sharpie?
Avery went to the parking lot where Coach Brackman's super, super nice 911 Porsche was and wrote on his car in big, bold letters, "Worst Attorney Award."
Oh, geez. And did Brackman ever press charges for this, to your knowledge?
Not that I know of. I mean, he was murdered so soon after the car incident, but Avery was kicked off the team this time for good.
And did the defendant accept this punishment?
No, not at all. Avery texted me and more other people on the team about talking to Brackman to get her back on.
Okay. Your Honor, permission to present this witness with what has been previously marked as Exhibit 14.
Granted.
May my technician share this with the jury?
Not with the jury, just with the witness at this
Just
point.
with the witness. My apologies. Ms. Cifuentes, do you recognize this exhibit?
I can't see it anymore.
It was taken down. You can put it back up for constructively showing it to the witness.
Thank you, Your Honor. Do you recognize this exhibit?
Yes, these are the screenshots of text messages between Avery and I. These are the screenshots that I sent the detective when I was approached. Sorry.
How do you know?
These are the screenshots that I took.
Is it a fair and accurate representation?
Yeah.
Your Honor, we move to enter Exhibit 14 into evidence.
Any objection?
Yes, Your Honor. The defense objects to the admission of these text messages under hearsay as well as the best evidence rule.
Response?
Your Honor, pursuant to Rule 801D1 and 801D2, these statements are made by both the party opponent and the witness currently testifying. They are exceptions to hearsay.
Overruled? These items are admitted.
Ms. Cifuentes, could you give the jury a summary of the defendant's request in that first text?
Sure. Is it okay if I annotate?
Your Honor, permission for this witness to annotate?
I'm going to have the witness testify, and then if counsel wishes to make an objection, they may.
Okay, so here Avery says, is there any way that you'd be willing to talk to Coach Brackman about having me back?
Did you ever talk to Coach Brackman?
Yes, I did. I talked to him about having her back on the team because, she is good at mock trial, and I did want to do well at state, but he completely shut me down. So I told her, Coach is pretty upset with you. I don't think he's going to change his mind. And she said here, well, if he's still upset about his car, then he's going to be really upset when he sees what I do to his house.
I see. And did you ask what she meant by that?
Yes, I said below that, what are you going to do to his house? And Avery said, I'm going to wait until he's at work, then break in and trash it, referring to his house.
Thank you. Ms. Bennett-Spurlock, you can take down this exhibit. Now, Ms. Cifuentes, did you see the defendant on the day of the murder, March 6th?
No, Avery was not at school that day. I have some classes with them and they went at school. The next thing I know, Mr. Brackman had been murdered.
Thank you, Ms. Cifuentes. Your Honor, no further questions at this time.
Any cross-examination?
Yes, Your Honor.
You may proceed.
Thank you. Good afternoon, Ms. Cifuentes.
Good afternoon.
Before we begin, I'd like to offer you my condolences. I know losing your coach must be hard for you.
Thank you.
I'd like to start with your time on the mock trial team. You were on the CHS mock trial team at the same time as Avery Becker, correct?
Yes, we did it on the team together for my first 3 years of high school.
And you claim that you and Avery were best friends and teammates who supported each other.
Absolutely.
However, you say that Avery was coasting on her good looks and didn't have any real talent or skill.
No, she didn't work hard. She didn't put in the effort. And that was why she was, demoted from A-team in the first place.
And you considered Avery's success in mock trial as a slap in the face.
Yeah, mock trial, the judges, the jury, it's not always fairly judged. And I believe that, some people on the team like me put in a lot of work, whereas she just didn't put in enough work.
And you were excited about the new role you would have on the team with Avery gone?
Yes.
Thank you. I'd like to move on to what happened after the accident. You were called in for an interview at the police station, correct?
Yes, Detective Markowitz called me.
And the purpose of this interview became investigating the text messages on your phone.
Yeah, she wanted me to bring in the text messages and, talk about how I knew the coach and all that.
However, this phone was left behind at your home at the time of the interview?
Yes, that morning my phone was not holding a charge, so I left it home charging.
However, the detective said that it was all right for you to send in screenshots of the alleged messages instead. I'd now like to direct your attention to Exhibit 14. My co-counsel, Leah Farrell, should be screen sharing that to you. Now, I'd like to discuss an inconsistency between the statement that you gave to the police as well as the text that you claim to have exchanged with Avery Becker. You told the police that Avery had asked you to convince Brackman to let her back on the team?
Yes.
And you went and asked Brackman?
Yes.
And Brackman had said no?
He shut me down.
And then you told Avery that the answer was no?
I said, I guess I could try, but after the car situation, I doubt anyone could change his mind.
And that's when Avery had talked about trashing Brackman's home?
Yes.
However, in these text messages, you say that you're going to ask Brackman in the future about letting Avery back on the team, and without knowing what Brackman's answer was, Avery immediately threatens to trash his house?
I say, I don't know, Coach is still pretty upset with you, and then I tell her, I guess I could try.
Exactly. In version 1, you asked Brackman, and Avery then makes the threat. However, in version 2, you haven't asked Brackman, and then Avery makes the threat. Correct?
I told her I doubt anyone could change his mind after he shut me down.
Your statement, yes, Mr. Fuentes, your statement, as well as the text messages exhibited in Exhibit 14 in front of us, are inconsistent. So was your statement to the police untrue, or are these text messages altered?
They were not inconsistent. I told her that I could try, but I also told her that, he wasn't going to change his mind, which was true because I talked to him and he shut me down.
Now, these are the alleged screenshots that you sent to the detective?
These are the screenshots that I sent to the detective.
However, these are just copies of what you claim to be the original text.
These are screenshots that I took from my phone that I sent to the detective.
And now you claim to no longer have this crucial piece of evidence, your phone, in your possession?
No, as I was saying, the battery wasn't working, and about 3 months ago, I got a new phone.
And you have no idea where it is now?
No, I got a new one.
So in the end, Avery says that these messages were faked, and because you got rid of your phone, there is no way to prove that these messages are real?
I don't know what the detective did or didn't do with the text messages after I sent them to her. All I know is that she accepted them.
Thank you. Your Honor, I have no further questions.
Any redirect?
Briefly, Your Honor.
Proceed.
Ms. Cifuentes, did you talk to your coach about letting the defendant back on the team?
Yes, I did. I made an impassioned plea to let her back on the team. At that point, we needed her to do well at state, and so I pled, but he completely shut me down, and I told Avery that he wasn't going to change his mind.
Thank you. Your Honor, no further questions.
Then the witness is excused. You may call your next witness.
The prosecution calls Ms. Kyle Kuzak to the stand at this time.
Ms. Kuzak, please remember that you are under oath. You may proceed, Ms. May.
Good afternoon. Could you please state your name and spell your last for the record?
Kyle Kuzak, Kuzak.
Ms. Kuzak, what do you do for a living?
I am a Colorado Bureau of Investigation Certified Crime Scene Reconstructor, or a CSR.
How long have you been doing this?
19 years.
What does this job entail?
I investigate all sorts of complex crimes, including home invasions, burglaries, and other property crimes, domestic violence, fatal accidents, and armed robberies.
And Ms. Kuzak, who do you work for?
I work for the city of Denver, and I have for the past 3 years.
Your Honor, pursuant to Rule 702, I now move to enter this witness as an expert in crime scene reconstruction.
Any objection?
Yes, Your Honor. The defense would like to voir dire.
You may proceed.
Good afternoon, Ms. Kuzak. I would like to start with your qualifications. You stated today that you have experience as a crime scene investigator,
Yes.
but you haven't provided a resume or CV to document where you have worked.
No, I am board certified, and I've been doing this for 19 years, so I didn't feel that that was necessary, no.
And you didn't provide a statement or record of university attended?
No, university was forever ago.
And no indication of the number of homicides or burglaries you've investigated?
No, I've been doing this for 19 years. I've done it countless times. Every day I do this, so.
And no record of any training or specialized education?
In my statement, I do mention that I am Colorado board certified, so.
Your Honor, pursuant to Rule 702, we object to this witness being admitted as an expert on the grounds that they provided no evidence that they possess the knowledge, skill, experience, training, or education be considered as such.
Ms. May, any response?
Yes, Your Honor. Pursuant to Rule 702, in order to be entered as an expert in this field, the witness must have only one of the following requirements of knowledge, skill, experience, training, or education. Ms. Kuzak has testified to her 19 years in this field, meaning that she has extensive experience, knowledge, and skill in this field.
At this time, I'm going to admit this expert. Ms. Awald, you are welcome to cross-examine her as you wish. Please proceed with your questions.
Ms. Kuzak, what is your involvement with the case here today?
I was called to visit the scene at 444 South Flower Street.
Whose house is this?
Mackenzie Brackman's.
Were you able to identify the victim there as Mr. Mackenzie Brackman?
Yes.
Other than visiting the scene of the crime, did you do any other work for this case?
Yes, I also reviewed all the police reports in this case, the evidence, the 4 ring security camera videos, the autopsy, and the photographs.
With your experienced background in this field, how do you go about conducting your investigations?
Well, I first assume that every case is going to trial, so I conduct a thorough investigation accordingly. And then starting from day 1, I memorialize, document, and organize all of my evidence with the mindset of future reconstruction.
And what's the benefit of conducting your work this way?
This ensures that I have an accurate and efficient flow of my CSR work, which I approach in a 5-step process.
What are those 5 steps?
Recognition and documentation, collection of evidence, evaluation of evidence, hypothesis and testing, and finally, reconstruction.
Did you go through each of those 5 steps in this case?
I did.
After gathering all of your evidence from this case, what conclusion did it ultimately lead you to?
Well, the ring security videos exhibit a perpetrator matching the exact general height and build of the defendant, Avery Becker, approaching Mackenzie Brackman's residence and breaking in.
Your Honor, permission for my co-counsel to screen share with the witness what has been previously marked as Exhibit 12.
You may.
Thank you. Thank you, Ms. Spurlock. Ms. Kuzak, were you able to watch Exhibit 12 or do you need it to be played again?
Yes, I was able to view it.
Perfect. What is Exhibit 12?
This is the video of the intruder unlawfully entering Mackenzie Brackman's home.
How do you know this?
I reviewed it in my investigation.
Is this video being played here today an accurate representation of the video that you reviewed in your investigation?
It is.
Your Honor, at this time, I now move to enter Exhibit 12 into evidence.
Any objection?
No objections, Your Honor.
So it's admitted.
Permission for my co-counsel, could you please play this again for the jury? Thank you. Ms. Kuzak, what conclusion did this video lead you to about the perpetrator?
Well, this video is critical because it shows the exact general height and build of the intruder, which matches the exact general height and build of the defendant, Avery Becker. It also shows that the perpetrator was wearing gloves, which is why no DNA evidence other than Mackenzie Brackman's was recovered from the scene.
Thank you. Co-counsel, you can stop sharing the screen now. Ms. Kuzak, you stated that along with your videos, you also analyzed photographs. What did these photographs show?
They showed scuff marks on the kitchen floor near the back door, an open drawer with several small knives in it, a knife block with an open slot for a large chef's knife, just like the one that we retrieved from the body, and a photo of a broken plate.
Did the photographs provide any insight into your investigation?
Yes, the floor scuffing indicated that there was close contact between 2 individuals.
Moving on, did you review the autopsy report in this case?
I did.
What did it tell you?
It establishes that the victim was only stabbed 1 time in the upper back shoulder area.
You mentioned that making timelines are a crucial part of your process. Did you make a timeline in this case that allowed you to come to a conclusion of the events of March 6th, 2020?
Yes, I did.
Could you go over this timeline for us?
Of course. First, the victim must have been alerted by the ring security camera as the intruder approached the residence. He then likely looked for a defense weapon in the knife drawer, but then proceeded to the knife block where he took the larger chef knives out to introduce into the encounter.
Based on this timeline, what did you conclude happened after the victim confronted the intruder?
The 2 likely struggled over the knife in the kitchen, causing the plate to crash to the floor and break. And in the ensuing struggle, the intruder obtained the chef's knife and disarmed the victim.
And then according to the evidence, what happened when the intruder grabbed the chef knife from the victim?
Well, based on the location and position of the stab wound in the victim, the intruder must have reached over the victim from a bear hug position and stabbed him in the upper back shoulder area.
Ms. Kuzak, were you aware that there were other expert witnesses working on this case?
Yes, I'm aware that Blake Van Owen's working this case for the defense.
Did you review Blake Van Owen's theories of this case?
I did.
Do you agree with them?
I don't.
Why do you not agree with them?
Blake Van Owen's theories are ridiculous because not only does Blake Van Owen regret to include critical information in this case, including the broken plate, the open knife drawer, the empty slot in the knife block, and the floor scuffing, but also Blake Van Owen suggests that Brackman was surprised, which is ridiculous.
Why is that ridiculous?
Mackenzie Brackman would not have been surprised because not only did he own Ring security cameras, which sole purpose is to notify homeowners of movement near the house, but Brackman would have surely also been notified by the opening of the back door and shuffling to the kitchen.
Was your investigation in this case thorough?
Yes.
Did you feel you had sufficient evidence to come to a conclusion?
Yes.
Ms. Cusack, in your expert opinion and your extensive experience creating timelines of events like this, what is your conclusion of this case?
In the end, this was clearly a planned burglary gone bad. The intruder had knowledge of the victim's residence and likely chose a time of day that would have placed the victim outside of the home. However, unfortunately, Mackenzie Brackman was present and alerted to the intruder's presence before the intruder entered the house and introduced a weapon into the encounter, which unfortunately he was disarmed with and killed in the ensuing struggle.
Thank you. No further questions at this time.
Very well. Any cross-examination?
Yes, Your Honor. I'd like to begin with your conclusions in this case. You stated that this was clearly a planned burglary gone bad,
Yes.
but then you stated that the intruder likely chose the time of day for your own imagined reason,
Yes, this is the conclusion that I came up with.
and you stated that the victim would surely have heard the back door slide open, but you do not know that definitely, do you?
No, but that is not fully important because we also know that Mackenzie Brackman owned Ring security cameras, which notify the homeowner of movement near the house.
Thank you, Ms. Cusack. Let's talk about your review of the crime scene evidence. Your analysis of blood spray and cast-off blood splatter droplets were based off of photos taken by the police,
Yes.
but those photos were corrupted, so your analysis cannot be independently verified.
Unfortunately, they were corrupted. However, well after I had reviewed them, so I was able to view all of the evidence before it was corrupted and base that on my conclusion.
And you admit that you were not able to recreate all segments?
I mean, it's nearly impossible to recreate all event segments in any case, but I am fully confident in my reconstruction of this case with all the evidence I was given.
And you had evidence that you could not place?
Like I said, it's fully impossible to place all evidence, but I placed the evidence to the best of my ability, and I'm 100% confident in this reconstruction.
So that was a yes.
Yes.
And you dismissed the likelihood that the victim was surprised because he owned a Ring app.
Yes, and also because the intruder opened the back door like we just watched and shuffled through the kitchen.
Thank you, Ms. Cusack. But you're speculating that the victim had his phone at that time?
I mean, yes. However, like I said, there are two other options that would have notified Brackman, so I am confident that Brackman was not surprised.
Let's move on to other possible theories. The expert witness for the defense, Professor Van Owen, gave a statement that contradicts your conclusions in this case?
Yes.
And you admit that Professor Van Owen's conclusions are outside of your own expertise?
Well, Professor Van Owen is not a crime scene reconstructor like I am, so I feel like I'm way more qualified to do this type of reconstruction.
Ms. Cusack, my question was not if you were more qualified. I was asking if Professor Blake Van Owen's conclusions are outside of your own expertise.
Yes, Van Owen's conclusions are outside of my expertise, but those are not the expertise that we need in this case. The expertise that we need are mine.
Thank you. And in your comprehensive, thorough investigation, you didn't note that in your witness tracking sheet that Avery Becker would claim to have been set up by the two other suspects in this case?
Can you repeat that question?
Yes, I can. In your comprehensive, thorough investigation, you didn't note in your witness tracking information sheet that Avery Becker claimed to have been set up by the two other suspects?
No.
And you didn't note that Taylor Perkins also supported this theory?
No, my affidavit is about the defendant, Avery Becker, so everything that I included in my statement is about the defendant.
And you list Blair Rollins in your witness as a suspect in your...
Yes.
Objection. Your Honor, this Ms. Alwold is asking my witness to testify to facts not in evidence based on her witness tracking sheet, which has not been entered into evidence at this time.
Response?
I will move on.
Very well.
And in this, you list Blair Rollins in your witness tracking information sheet, correct?
Objection, Your Honor. She's still asking my witness to testify to this.
Any response from you, Ms. Awald?
Yes, I can lay some foundation, or I can admit this evidence.
I'm going to allow it to your discretion. Just understand that there may be further objections.
I will move on, actually. Thank you. Are you aware that there was a recording of Jonathan Rawlings promising to get revenge on Mackenzie Brackman?
Yes, I'm aware.
Objection, Your Honor.
What's the objection?
Facts not in evidence. When she said that the recording contains Mr. Rawlings saying that he will get revenge, that is asking my witness to testify to facts that have not been admitted into evidence.
Any response?
No response, Your Honor.
Asking the question is asking for the evidence to be admitted, so I'm going to overrule that objection and allow you to continue with your question.
Thank you. Would you like me to re-ask that question?
No need to, thank you.
All right. And you did not include this in your thorough and comprehensive investigation?
No, like I said, my affidavit is about the defendant, Avery Becker. This was not relevant.
Thank you, Your Honor. I have no further questions.
Can you redirect?
Yes, Your Honor. Ms. Cusack, did you conduct a thorough investigation in this case?
Yes.
Did you have sufficient evidence to come to a conclusion?
Yes.
What is that conclusion?
That it was clearly a planned burglary gone bad and that the defendant, Avery Becker, killed Brackman.
Thank you. No further questions at this time, Your Honor.
All right, this may be excused. Does the prosecution wish to call any additional witnesses?
Yes, Your Honor. The prosecution calls Detective Markowitz to the stand.
Detective Markowitz, you're aware you're still under oath?
Yes, Your Honor.
All right, then you may proceed, Ms. Sinishin.
Good afternoon, Ms. Markowitz. Could you please state your name and spell your last for the record?
Yes, Jordan Markowitz, Markowitz.
Ms. Markowitz, what is your current occupation?
I'm a homicide detective at the Denver Police Department.
And how long have you been working in law enforcement?
I have been with the PD for 13 years, and if my math is right, I've been a homicide detective for 7.
And do you have any specialized training as a homicide detective?
Yes, as it pertains to this case, I have my certification in cell phone technology and forensic data recovery, which I received from the American Academy for Law Enforcement.
Ms. Markowitz, how often would you say you use this training in your work?
I use my knowledge of cell phones constantly. I mean, I've downloaded the contents of hundreds of phones, and I've used cell tower and antenna data, just like I did in this case, in probably over 50 similar cases.
Your Honor, we move to enter Detective Markowitz as an expert in homicide investigation, as well as cell phone data recovery and analysis, pursuant to Rule 702.
Any objection?
No objections, Your Honor.
The witness is so admitted.
Thank you, Your Honor. Detective Markowitz, how did you become involved in this case?
Yes, I was assigned to investigate the death of Mackenzie Brackman on March 6th of 2020.
And did you visit the crime scene?
I was able to visit the crime scene pretty much immediately after the 911 call was dispatched.
And what did you observe upon arriving, Detective?
When I first arrived at the Brackman residence, I observed that the front door was open, and I observed Mr. Brackman, who was face down just inside the doorway of the home. Next to Mr. Brackman, there was a large chef's knife, and due to the stab wound, it was clear that that had been the murder weapon in this case.
Your Honor, permission for my co-counsel to screen share Exhibit 1.
Granted. And for all counsel's use, if you are going to just be screen sharing something that you are openly saying that you are sharing with the witness, you can go ahead and do that as long as you explain what you are showing to the witness.
Thank you, Your Honor. Detective, could you go ahead and identify this exhibit?
Yes, this is a photo of Mackenzie Brackman.
How do you know this?
I observed this scene and I was made aware of this exhibit because my police department took these pictures.
And is it a fair and accurate representation of those photos?
Yes.
Your Honor, we move to enter Exhibit 1 into evidence.
Any objection?
Yes, Your Honor. The defense objects under Rule 403. This photograph must be excluded because its probative value is substantially outweighed by a danger of unfair prejudice. In this case, the pictures are more prejudicial than probative because they are likely to inflame the passions of the jury. These pictures will do nothing to inform the jury as to the identity of the killer, and in addition, testimony of the expert on stand should be sufficient to demonstrate relevant facts to the jury.
Response?
Your Honor, I understand that these photos are difficult to look at, but this is a murder trial.
Overruled. The exhibit is admitted.
Detective, what did you do after making these initial observations?
So this picture pretty much shows exactly what I just said. It shows my initial observations, but I actually did not end up entering the home through the front door. I ended up walking around the residence where I observed 3 Ring doorbell cameras, and I actually entered the home through the back door.
And what was the state of the home, Detective?
When I entered the back door, I entered into the dining room, which was in a state of disarray, I'd say. There had been a chair that was tipped over and a broken plate on the floor.
And what did you observe within the kitchen, Detective?
When I walked from the dining room to the kitchen, I observed a open drawer with just like a ton of knives in it, and also a knife block, which was on the kitchen counter, and it had one empty slot, which would fit the chef's knife that I had seen next to Brackman's body.
So what did you conclude based on these observations?
So the disarray in the dining room and the knives in the kitchen led me to believe that the intruder had come in through the back door, just like the Ring video showed, and Brackman had actually been alerted to that intruder, either through the Ring doorbell or through the noise. So Brackman armed himself with a knife, and then in the dining room, a struggle ensued. That's why there was like the broken plate, and then the intruder was able to get a hold of the knife and fatally stab Mr. Brackman.
Ms. Markowitz, in your expert opinion, did the intruder enter the residence with a knife?
It simply doesn't make logical sense for the intruder to have brought their own knife. Brackman, seeing the knives in the kitchen, it was pretty clear that Brackman had grabbed the knife from his own home.
So what did you do next in your investigation?
Like any good investigator, I turned to the facts to see who had murdered Mackenzie Brackman.
And what did you find?
My first step was, like I mentioned earlier, I have my cell phone training and expertise. So my first step was to download the contents of Brackman's phone. And I learned from his phone that he was a defense attorney, which I already knew, as well as a coach for Colorado high school mock trial team, which he seemed to be really passionate about, just seeing there were a bunch of texts about it. So I actually got the contact information for all the kids on the mock trial team just to speak with them.
And did you end up speaking with them?
Yes, I did. The first name on the list, Alex Cifuentes, was super helpful. I spoke with her over the phone.
And can you tell us about that phone call?
Yes. Alex Cifuentes told me that a fellow student on the mock trial team, Avery Becker, had told her that Avery Becker planned to break into and trash Mr. Brackman's home.
So what did you do after learning about this plan to trash the home?
I knew that this was key, so I called Alex Cifuentes and her family in for an interview at the PD headquarters. I asked to see the pictures, but she had forgotten her phone that day. She said something about like it not holding charge. So I asked her for screenshots to verify their conversation.
Okay, and what did you do after this interview with Ms. Cifuentes?
So I knew that Avery Becker was going to play a key role in this case. So I reached out to Becker to try and get an interview, but Becker lawyered up, so I couldn't. And then I got a warrant to search Becker's phone, but Becker's lawyer informed me that she had lost it. So then I finally ended up getting a warrant to get the cell tower data as it pertains to Avery Becker's phone on March 6th.
And Detective, could you tell us about how cell tower records help an investigation?
Absolutely. So anytime you make or receive a call or text, your phone is going to communicate with the nearest cell tower, usually. And what essentially I do is I speak to cell phone providers and I ask them for the information and locations of these towers that the phone communicated with. And that's going to give me a rough idea of the location of the phone on that day.
If my co-counsel could go ahead and share Exhibit 16. Detective, could you identify this exhibit, please?
Yes, this is a diagram that I prepared as to the cell tower records from that day.
And how do you know this?
Because I created it.
And is it a fair and accurate representation of the diagram you created?
Yes.
Your Honor, we move to admit Exhibit 16 into evidence.
Objections?
Yes, Your Honor. Under Rule 801, the defense objects to this map, to the admission of not the map itself, but to the admission of the blue line drawn by the detective. The drawing was clearly made out of court and purports to be a statement of the movements of Avery Becker on the day of the murder, which is undeniably the truth of the matter that Detective Markowitz is attempting to assert. Now, if the detective wants to testify as to these movements, we have no objection, but this figure cannot be admitted under the rules of hearsay.
Response?
Your Honor, we would move to enter the exhibit with the constructive exclusion of the dotted line.
Ms. Farrell, does that have any problem with you?
No issues with me.
Okay, so it will be subjectively entered as into evidence with the constructive removal of the dotted blue line.
Thank you, Your Honor. Permission to, this is published to the jury. Yes, Your Honor.
You may.
Thank you. Detective, could you tell us a little bit about this exhibit?
Absolutely. So as we can see on this exhibit, there are 3 red arcs. We've got 1, 2, 3, and these are going to be the cell tower antennas that Becker's phone communicated with throughout the day. And next to these are going to be the times at which Becker's phone communicated. And so up here at 12:47, we see that Becker's phone was in range of Becker's home. Down here at 12:55, we see that Becker's phone was traveling south. And then finally, we have a series of messages here that conclude at 1:17, which of course show the defendant at Mr. Brackman's home.
So did Becker's phone receive any communications later on the day of the murder?
No. At 13:20 hours on March 6th of 2020, Becker's phone was shut off, presumably either powered off or turned into airplane mode, and I assume that it was later disposed of after the murder.
So Detective, would you mind summing up your conclusions based on this cell tower data?
Absolutely. So I can draw for you a line of the path that I believe Avery Becker took on that day. Becker traveled down this path, leading her towards Mr. Brackman's home. And this cell tower data clearly shows that she traveled from her home to Brackman's home at the time of the murder, placing her at the crime scene.
Thank you, Detective. This exhibit can now be taken down from the screen share feature. Detective Markowitz, in your expert opinion, how was Mackenzie Brackman murdered?
Yes. So the text messages show that Avery Becker went to Mackenzie Brackman's house on March 6th of 2020 in order to get revenge. Then Brackman was alerted to Becker's presence, either by the Ring doorbell or by the sound, and ended up grabbing a knife from his kitchen to defend himself. A struggle ensued and Becker got a hold of the knife, fatally stabbing Mr. Brackman.
Thank you, Your Honor. No further questions.
Any cross-examination?
Yes, Your Honor. Before I begin, could I get a time check?
10 minutes and 41 seconds remaining.
All right, thank you. Good afternoon, Detective Markowitz.
Good afternoon.
Let's start with the crime scene. You arrived at the crime scene and observed a Ring camera.
I observed 3.
And the person observed from the videos from March 6th was wearing gloves, a hoodie, and a Halloween mask.
Yes, and they were the height and build of Avery Becker.
All right, so as you just said, they weren't showing any identifiable features other than height and build?
Yes. Yeah, no other features besides height and build, of course.
Both of which can easily be altered with clothing and padding?
I wouldn't say you can make yourself taller with clothing, no.
And this was a part in your conclusion that the perpetrator was Avery Becker.
I mean, I would say my main conclusion came from the text messages that show Avery's intent.
You collected photographs of the blood splatter in the crime scene, correct?
My team did.
But these photographs are corrupted and cannot be accessed for independent analysis?
No, but they're not really relevant to whether or not Avery Becker committed this crime.
All right. Let's move on to the cell phone and texts. You examined cell data records in this case?
Yes.
And these records were for March 6th, 2020?
Yes, they were.
And you cannot say for certain who was in possession of the phone at this time, can you?
No, but it was Avery Becker's phone. It makes sense that it was in her possession. And it was also at her house to start the day.
All right. And you noted that repeated calls and texts were received from Taylor Perkins?
Yes. Well, I wouldn't say like a few texts throughout the day, but not that frequent.
So that is a yes, you did note it.
Yes, there were more than one calls and texts.
And all of these calls and texts went unanswered?
Yes.
Yet you never considered that the pattern of multiple calls and texts was in line with a lost phone?
I have considered that.
All right. You received screenshots of incriminating texts from Alex Cifuentes?
Yes, that pointed me to Avery Becker.
All right, but you never saw the original versions of the texts?
No, I wasn't able to.
This is because Ms. Cifuentes didn't bring her phone to the interview?
She had forgotten it on that day, and I was the one who asked her for screenshots.
All right, and you found it very odd that a teenager came to the interview without her phone, correct?
Yes, but I heard her testify on the stand that it wasn't holding charge, and that happens to the best of us.
All right. And you never followed up and secured the original text evidence?
I attempted to. I attempted to get a hold of Avery Becker's phone, but I was unable to because she lost it.
All right, so that is a yes, you never secured the original text evidence.
I was never able to.
And you would agree that it's standard procedure to preserve decisive evidence, such as the texts?
Yes, if I would have been able to, I would have.
And could you have obtained the original text evidence from Alex Cifuentes' phone?
No, because she didn't bring it to the interview.
Could you have asked her to come in at a later date?
That's not in my statement. Would you like me to answer that?
I'll move on. So there is no way for you to know for certain that these text messages are authentic?
No.
Now, let's talk about what you didn't do. You considered that the murder could have been the work of a disgruntled ex-client?
That was my first thought, but then I saw the text with Avery Becker.
Blair Rollins is another suspect in this case, correct?
No, Blair was not a suspect of mine.
You're aware that Exhibit 16 marks Blair Rollins' house?
Yes, I am.
And are you aware that the prosecution's expert, Kyle Cusack, lists Blair Rollins as a suspect in her information tracking sheet?
Yes, but Blair is not here in court today because we decided that the most logical person who committed this crime is Avery Becker.
All right. And you've listened to the audio recording of Blair Rollins swearing revenge against Brackman? Blair Rollins' father, excuse me.
I don't believe that I have. No.
You haven't listened to the audio of a suspect in this case swearing revenge against the victim?
That's not my statement. Would you like me to answer that?
I'll move on. Your Honor, permission for a co-counsel to publish to the jury what has already been admitted as Exhibit 16.
Granted.
This is the drawing you made in regards to Miss Becker's phone's whereabouts on March 6th, is it not?
Yes.
And in regards to Exhibit 16, Miss Rollins' house is very close to that of Miss Becker?
Yes, it is. But Becker had her phone and was at her house at the start of the day.
That wasn't what I was asking. I was asking if you were aware that Miss Rollins' house is very close to that of Miss Becker's.
I mean, according to this picture, sure.
So the route from either house to Mr. Brackman's would follow a roughly similar route to your blue line?
I didn't think that the blue line was on this exhibit.
Would follow a roughly similar route to the one you testified to?
Sure.
Thank you, co-counsel. You can stop sharing. And you don't have data records for Blair Rollins' phone on March 6th?
That's not my statement. Would you like me to answer that?
No, that's fine. No further questions, Your Honor.
Any redirect?
No, Your Honor. Thank you.
Does the prosecution wish to call any additional witnesses?
No, Your Honor. The prosecution rests.
Are there any motions to be made at this time?
Yes, Your Honor. The defense would like to call Avery Becker to the stand.
Prior to calling any defense witnesses, are there any motions that the defense would like to make at this time?
The prosecution makes none, Your Honor.
Your Honor, the defense has no motions to make at this time.
Very well. Would the defense like to call any witnesses?
Yes, Your Honor. The defense would like to call Avery Becker to the stand.
Ms. Becker, you were called that you are under oath.
Yes, I do, Your Honor. Oh, my apologies.
No problem.
May I begin?
You may.
Good afternoon, Ms. Becker.
Good afternoon.
Can you state your name and spell it for the court?
Yes, my name is Avery Becker, and that's spelled Averybecker.
I'd like to start with some background information. What is your relationship to Mackenzie Brackman?
Well, Coach Brackman was the coach on my mock trial team. I did a mock trial in high school for a while, so I'd say that Coach Brackman and I knew each other pretty well.
And when did you join mock trial?
I joined my freshman year, and then I did it all 4 years of high school.
And how was Mr. Brackman as a coach?
Well, for starters, I just want to say that I was really, really shocked and saddened to hear about what happened to Coach Brackman. But if I have to be honest, Brackman and I didn't always see eye to eye on everything. He constantly kept us at practice going over the same thing over and over again. But he got our team to a place where we were competitive, and I could tell that he cared a lot about his students.
And how many times have you been to his house for mock trial or other reasons?
I've never been to Coach Brackman's house. I didn't even know where he lived.
And now let's turn to your relationship between you and Taylor Perkins. Who is Taylor Perkins?
Well, Taylor is my best friend on the mock trial team. He's still my best friend. But yeah, we had a lot of fun in mock trial. We used it as a way to text each other, hang out with each other, normal things that teenagers do in after-school activities.
And how did Mr. Brackman respond to this?
Well, Coach Brackman seemed to get a little upset whenever he thought that Taylor and I weren't paying attention. And I guess he felt that we couldn't focus, so he actually ended up demoting me down to the B team, which I didn't really understand.
Objection? What's your objections?
Speculation.
Response?
Your Honor, this is based on the witnesses' rationally based perceptions of their interactions and relations with their coach, Brackman.
Any response?
Yes, Your Honor. The witness has testified to no experiences that would suggest what Mr. Brackman felt.
I'm going to overrule and allow the lay opinion. Continue, please.
I'd also like to discuss your relationship with Alex Fuentes. What is your relationship with Alex?
Well, Alex was another member on the mock trial team. I really wouldn't consider us to be friends. Her and I never really got along.
And what was it like being on the team with Alex?
Well, personally, I felt that she wanted me off the team so that she could be named best attorney.
And what was the nature of your relationship outside of school with Alex?
Well, Alex would be the last person I would ask for help on anything. So those text messages that Alex claims I sent, I never sent them, and I don't even know what they say.
Thank you. Now let's focus on what happened when you got removed from the team. What was going on beforehand?
Well, honestly, I was pretty upset. Brackman never gave us any of the credit for the work that we did. He constantly criticized my work and the work of others. And like I mentioned before, he ended up demoting me down to the B team, which personally I felt wasn't good for the A team.
And why were you eventually removed from the team?
I made one of the worst mistakes after practice one day. I was at the whiteboard that we use to outline good and bad things that we do during competitions. And I got frustrated with a couple of the comments that Coach Brackman made about me, and I ended up storming out of practice and writing Worst Attorney Award on the hood of his car.
What did you write Worst Attorney Award on his car with?
Well, at the time, I thought it was an expo marker because that was because I was about to write on the whiteboard. So I thought it was an expo marker, but it turned out to be a permanent marker. And when Coach Brackman found out, he kicked me off the team for good.
And what were you thinking in that moment?
Well, in that moment, I was so angry that I just wanted him to know exactly what I thought. But that isn't what I thought. And I'm extremely ashamed that I did it, and I never should have done it.
And what happened afterwards?
Well, like I mentioned before, it turned out I'd made an even bigger mistake because the marker that I had used was permanent. And after Coach Brackman kicked me off the team for good, I was pretty upset.
What did you do afterwards?
Well, like I said, my entire mock trial career was coming to a close, and it was really, really devastating for me. But I went home and talked to my mom, and she told me that I should apologize, and that's exactly what I did.
And how was that?
Well, I constantly tried to apologize to Brackman, but he just kept ignoring me. I offered to scrub his car, I offered to have his car repainted, but I never got a response back, and I'm devastated I never got a chance to apologize in person.
Thank you. The prosecution introduced testimony about the alleged whereabouts of your phone, and I'd like to talk to you about your phone and when you last saw it. When did you last see your phone?
I last saw my phone on March 5th, and I haven't seen it since.
And where do you believe that you lost it?
Well, on March 5th, Taylor and I went to the Fry Shack, and then we went to the mall. But at the Fry Shack, we were playing games on our phones, and there were a bunch of mock trial people there, including Alex Cifuentes.
Was there any interaction between you and Alex?
Yeah, Alex and I talked, and we had a conversation.
And what happened to your phone?
Well, I got up on March 6th and realized I didn't have it.
And what did you do to try to find it?
So I went over to Taylor's house, and Taylor and I decided to skip school in order to go look for it. So we went to the mall and we went to the Fry Shack.
What other ways did you try to find your phone?
Well, Taylor had his phone, so he kept trying to call and text my phone, but we assumed that it was either dead or stolen because it kept going immediately to voicemail.
Finally, I'd like to talk about Blair Rollins. How familiar are you with Blair Rollins?
Well, everyone knows who Blair Rollins was. They were pretty notable around CHS, or Colorado High School, I should say.
And what do you know about Blair Rollins' relationship to Mackenzie Brackman?
Well, everybody...
Objection, Your Honor.
What's your objection?
Lack of personal knowledge.
Response?
I can lay some foundation.
Please do. Sustained.
What was your impression of Blair?
Blair seemed a little off to me. They were kind of a loner at school, and they had a pretty notable reputation.
Was there anything about Blair that was out of the ordinary?
Yeah, especially their relationship to Coach Brackman.
What was their relationship to Mackenzie Brackman?
Well, everybody knows that Coach Brackman lost the case that sent Blair's father to jail.
And what do you make of that?
Well, to me, it seemed like they didn't really get along.
Thank you. Are you aware of the ring videos?
Yes, I am aware of the ring videos.
And in the video, there's a figure. Do you recognize this figure?
No, and I think it's absolutely crazy that people think that the person in the video is me. You couldn't see the face or any identifiable features, and you can easily mistake it for someone else.
Does that look like anyone else?
Yeah, it could easily be mistaken for Blair Rollins.
And why do you say that?
Anyone who saw me and Blair walking away could easily confuse the two of us. And now Blair's disappeared.
Thank you. Finally, for the jury, did you kill Mackenzie Brackman?
No, I did not kill Mackenzie Brackman.
Thank you, Your Honor. I have no further questions.
Any cross-examination?
Yes, Your Honor.
You may proceed.
Thank you, Your Honor. Good afternoon, Ms. Becker.
Good afternoon.
You were really good at mock trial, right?
Yes, that is true.
Today, your teammate, Ms. Cifuentes, testified that you had this amazing ability to get up on the witness stand in mock trial and save the jury any way you needed to. You heard this?
I did hear her testimony, yes.
And you even won awards for your ability to persuade the jury with anything you said. Is that right?
I guess I was just following what mock trial was about. So yeah, I was pretty good at
You
it.
said, thank you, Ms.
Oh,
Becker. You said that you could get the jury like putty in your hands.
Yeah, I was really good at it, and I worked really hard at it. So yeah.
Ms. Becker, despite the awards you won, Brackman was constantly criticizing your work, wasn't he?
Yes.
He demoted you from A team to B team as a senior?
Yes, and that was pretty harsh.
It really upset you, didn't it?
Yeah, it did, of course. I'd worked so hard to be on the A team.
So you said you did everything you could to convince Brackman to put you back on the A team, is that right?
Well, almost everything I could, but yeah.
Because mock trial meant everything to you, isn't that right, Miss Becker?
Yeah, mock trial meant a lot to me.
At the regional tournament, you won the Best Attorney Award.
That is correct, yes.
But despite this, Brackman still criticized your work, right?
Yeah, he made a lot of really mean comments to me.
For example, he said that you did not deserve the award.
Yes.
And this made you really angry, didn't it?
Of course, I guess it would make everyone angry, but I don't agree with what I did when I was
Miss Becker. You called your coach the worst coach in the state because you were so angry.
I don't believe that, though. But yes, it did happen.
And you were so angry that you stormed out of practice that night?
Yes, I was really upset.
And you recall seeing what you called his obnoxious white Porsche?
Yes, again, there are parts of Brackman I didn't like, but everyone can recall someone that they did not like.
You knew that Brackman loved this car, didn't you?
I guess, yeah.
So you took a permanent marker and wrote in huge letters across the hood of the Porsche, Worst Attorney Award. Is that right, Miss Becker?
As a dumb mistake, yes, I did do that, unfortunately.
So you damaged your coach's personal property.
And I'm completely ashamed of it, but I had no ill intention towards my coach.
Miss Becker, after you did this, Brackman refused to talk to you.
Yes, that is true.
And this upset you.
Of course it did.
You said that it devastated you.
Of course. My entire mock trial career was coming to a close. It felt really terrible.
Luckily, Brackman did not press charges.
Of course, yeah, and that just proves how amazing of a relationship we could have.
Thank you, Miss Becker. That's because Brackman was murdered before he could press charges, isn't it?
Yeah, and that's really terrible because I never got a chance to apologize to him.
Miss Becker, after you vandalized the car, you had a conversation with your mom. Is that right?
Yes, a private conversation.
But you failed to tell her that you would vandalize the car. Is that right?
I was completely ashamed of it, and I didn't want to bring it up because of how horrible I felt.
But what you did tell her, Miss Becker, is that you would get back in Mackenzie Brackman if it was the last thing you did. Is that right?
It was a private conversation I had at a time in my life when I wasn't at my best. But yes, unfortunately, I made a lot of mistakes that day, and that sentence was one of them.
So, Miss Becker, when Brackman saw what you had done to his beloved Porsche, he kicked you off the mock trial team, right?
That is correct.
And this made you even angrier.
Of course, but my mom calmed me down and told me that I should just go apologize, and that's what I did.
Miss Becker, your teammate, Miss Cifuentes, testified that you texted her shortly after being kicked off of the mock trial team. She testified that you texted her, if he's still upset about his car, then wait until he sees what I do to his house. You heard this?
I did hear her testimony, yes.
And she then testified that you texted her, I'm going to wait until he's at work, then break in and trash the house. You heard this, Miss Becker?
I heard her testimony, but again, I can't really answer questions about the specifics of the text messages as I have not sent them.
That's right, because you deny sending these texts, don't you?
Yeah, I never sent them.
And you deny sending these texts because you allegedly lost your phone on the day of the murder. Is that right?
I did lose my phone, but yes.
Miss Becker, on the day of the murder, you were with Mr. Taylor Perkins, right?
That is correct.
And Mr. Perkins is your best friend, wouldn't you say?
Yes, he's easily my best friend.
And he's the person you would go to if you needed anything. Is that right, Miss Becker?
We relied on each other, of course. That's what best friends are for.
Miss Becker, Mr. Perkins is the only one here today who can confirm your alibi on the day of the murder, right?
He's the one I asked to come with me, so yes, it makes sense that he's here.
But you talked to Mr. Perkins after Brackman was found murdered, right?
That's not in my witness statement, I don't think. I don't recall.
Your Honor, if you could give me a minute to review the affidavit. Miss Becker, you were not at school on the day of the murder, were you?
I was looking for my lost phone, but yes.
So that's a no.
No, I was not at school on that day, but
No
Taylor.
further questions, Your Honor. Thank you, Miss Becker.
Any redirect?
My apologies, Your Honor. I'm in a room that has
Motion sensitive lighting?
motion sensor lights. May I?
Yes, please walk around, wave your arms, whatever you need to do.
While she is doing that, can I get a quick time check?
I believe that you have 18 minutes and 24 seconds remaining.
Thank you so much.
You may proceed.
All right, thank you. Ms. Becker, what were you feeling in that exact moment when you talked to your mother?
Anger. I was so devastated that the entire thing, my entire mock trial career was coming to a close. And obviously I had a lot of really unhealthy emotions that I didn't act on thanks to the fact that my mother told me not to.
And why is Taylor here to give a statement?
Taylor's the one that I asked to come with me. It makes complete sense that he's here to testify as to where I was that day.
Thank you, Your Honor. I have no further questions.
The witness may be excused. Do you have any other witnesses you wish to call?
Yes, Your Honor. The defense calls Taylor Perkins to the stand.
Very well.
Good afternoon, Mr. Perkins.
Good afternoon.
Could you state your name and spell it for the court?
Taylor Perkins, TaylorPerkins.
All right. Can you start by telling us about your connection with this case?
So I was on the mock trial team at Colorado High School with Avery, who is my best friend, and we were both seniors.
What was Avery's role on the team?
Well, she loved it like nothing else. She always wanted to be a lawyer, and she was really good at it. She did a lot of improvisation and she wasn't very prepared, but she was still easily the best on the team.
Did Avery get along with everyone on the team?
She got along well with most of the team, but some people were bitter about how well she did.
How did she get along with Alex Cifuentes?
Not great. On the surface, they were polite, but Avery was the star of the team, and Alex wasn't, and that just caused some tension between them.
How did you get along with Alex?
Alex always came off as insincere or passive-aggressive to me.
Let's talk about what happened with Avery and the mock trial team. What happened before regionals to change Avery's status with the team?
So Avery showed up extremely unprepared about a month before last year's regionals, and Coach Brackman lost it. He automatically demoted her to the B team.
And after he demoted her, what did you do?
I left the team so he would have to put Avery back on to the A team.
Whose idea was that?
It was 100% my idea. Avery didn't ask me to do it. I just knew it was the right thing to do.
Once Avery was back on, were there any more problems?
Coach Brackman and Avery got into a fight, and Avery rode on his car.
Objection, Your Honor, lack of personal knowledge.
Response?
I can move on, Your Honor.
Sustained.
Let's talk about what happened after Avery was kicked off the team. What did the two of you do the Thursday after Avery was kicked off?
We went to the Fry Shack and ran into the rest of the mock trial team, including Alex.
And what day was that?
March 5th, the day before Coach Brackman was killed.
Did Avery ever leave her phone out while you were at the fry shack?
Yeah, she got upset after talking to Alex and went to the bathroom, leaving her phone on the table. Alex stayed and we talked a bit, and when Avery came back, we just left.
When did you realize something had happened to her phone?
The next morning, Avery wasn't replying to my texts when she was coming to pick me up to go to school, and I asked her all about it, and then she realized it was lost.
What did the two of you do after you realized it was gone?
Well, we decided that nothing important was going on at school, so we just decided to skip and go look for it, and I called it a bunch of times, but it just automatically went to voicemail.
When did you find out Coach Brackman was dead?
The same time as everyone else, a while after it happened.
Did you and Avery discuss Coach Brackman's death?
Avery and I talked about it, but we just had no idea what happened.
Finally, I'd like to talk about Blair Rollins. Do you know Blair Rollins?
Blair went to CHS with us. I wasn't friends with Blair because they were a little weird.
Did you ever see Blair and Alex together?
All the time.
Do you know if Blair knew Coach Brackman?
Yeah, Blair knew him.
Why do you say that?
Well, everyone knows that Coach Brackman lost the case that sent Blair's dad to jail.
What was Blair's reputation in school?
We all thought Blair was just a little creepy and violent, especially after what happened to her dad.
Was Blair Rollins in school on March 6th?
No, not that I can remember.
Have you seen Blair Rollins since Coach Brackman's death?
No, Blair has pretty much disappeared.
Finally, is there any way that Avery could have killed Coach Brackman?
No, she was with me the entire time.
All right. Thank you. I have no further questions, Your Honor.
In cross-examination,
Yes, Your Honor.
please proceed.
Mr. Perkins, you've known Avery for a long time, correct?
Yes.
You're incredibly close friends with Avery.
Yeah, we're best friends.
You joined the mock trial team just because of Avery.
Yeah, we thought it would be a great way to hang out.
And through the amount of time you spent at mock trial, you observed the relationship between Mr. Brackman and the defendant.
Yes.
You observed the tension and fighting between the two of them.
Yep.
And eventually you decided to quit mock trial for Avery.
Yes.
So you are an incredibly loyal friend.
Yeah.
And you were aware that you were Miss Becker's only alibi for this day?
Yes.
Mr. Perkins, after Avery was kicked off the team tried to get her back on, correct?
Well, she tried asking the people to get her back on the team.
She wanted back on the team so bad that she even texted Alex Fuentes?
I have no idea if she texted Alex. As I stated, I have no idea who she texted, so I don't know if she texted Alex.
Yet you did say that Avery texted everyone on the team.
Almost everyone.
You said Avery texted everyone on this team.
Sorry, I must have misspoken.
So everyone on the team would include Alex Fuentes.
Probably, but I have no idea.
Did you observe to be Alex and the defendant to be good friends?
They were polite, not good friends.
Mr. Perkins, you were not at school the day that Mr. Brackman was killed, correct?
No, I was not.
You were with the defendant all day?
Yep. Yes, I was.
Looking for Miss Becker's phone?
Yes.
You called and texted the phone while looking for it?
Yes.
Yet throughout the entire day you spent looking for the phone, you only called it 5 times.
Possibly, yeah.
You stated that you were nowhere near Mr. Brackman's house.
Yep.
So you know where Mr. Brackman lives.
Yeah.
Mr. Perkins, you spoke to the defendant prior to testifying today, but after Mr. Brackman was murdered.
Yes.
And when you talked to the defendant, she brought up the idea that Blair Rollins may be involved.
Yeah.
So the defendant in the case today, the only suspect on trial, introduced to you the idea that someone else could have committed this murder.
Yeah.
Thank you. No further questions, Your Honor.
Any redirect?
Yes, Your Honor, a brief one.
Please proceed.
Mr. Perkins, were you looking for Avery's phone that entire day?
Yes. Most of the day. Yeah, basically.
And do you know if Avery knew where Mr. Brackman lived?
Objection, lack of personal knowledge.
Response?
I'll move on, Your Honor. Mr. Perkins, while you do consider yourself a loyal friend, would you say you would lie? Would you say you would lie for your best friend?
That's hard. It depends. No, not right now. No.
Thank you, Your Honor. I have no further questions.
All right, the witness may be excused. Do you have any additional witnesses you wish to call?
Yes, Your Honor, the defense would like to call Professor Blake Van Owen to the stand.
Professor, please be
begin?
reminded that you're under oath and you may begin.
Before we begin, may I have a brief time check?
12 minutes and 25 seconds.
Thank you very much. Good afternoon, Professor Van Owen.
Good afternoon.
Would you please state your name and spell out your last name for the court?
Yes, my name is Professor Blake Van Owen, Vanowen.
Thank you. I'd like to start with your background, education, as well as your experience. What do you do for a living?
Well, I'm a private investigator, a professor, and an expert witness.
And where did your experience in this field begin?
I began in the Aurora Police Department.
And how did your experience develop?
Well, I worked as a resource officer, security guard, and then went into private investigation.
And what other qualifications have you obtained?
I've earned a master's degree in criminal justice, and for the last 5 years, I've been teaching about police practices and social justice at U Denver, after teaching about police procedures at Colorado Community College of the Rockies.
And how does your education as well as experience relate to this case?
Well, I have the experience and training to recognize and examine the evidence of this case.
And what would you consider to be your field of expertise?
Police practices, forensic evidence, and crime scene reconstruction.
And why would you consider these to be your fields of expertise?
I've been accepted as defense expert in over 100 cases in the U.S. District Courts, and with my expertise in crime reconstruction and general police investigation tactics, with a specialty in forensic evidence included in those 100 cases.
Thank you. Your Honor, at this time, the defense moves to admit Professor Blake Van Owen as an expert in police practices, forensic evidence, as well as crime scene reconstruction.
Any objection?
No, Your Honor, all issues with credibility will be addressed on cross.
Very well, the witness is so admitted.
Thank you. Professor Van Owen, how did you come to be involved in this case?
Well, I was hired by the defense because there was concern that the police investigation was being mishandled and done sloppily.
And once you were hired, what activities did you conduct?
I reviewed the police reports and crime scene reconstruction conducted by Kyle Kuzak, as well as the cell tower reports and exhibits prepared by Detective Markowitz. Additionally, I've conducted my own partial investigation in areas I feel were neglected.
Let's talk about the police's efforts to investigate. What did you notice?
Well, I noticed that there was many inconsistencies with the first investigation, such as the alleged murder weapon, scene of the crime, and as well as clues that could have helped us reach a more concrete conclusion.
Can you describe your crime scene reconstruction?
Yes, I reconstructed the crime scene and analyzed how the murder would have played out.
And what did you determine about the appearance of the intruder?
Well, in Exhibit 12, the video shows that the intruder couldn't have been much bigger than Mr. Brackman himself.
And in your investigation, you investigated the alleged murder weapon. What caught your attention about it?
Well, I noticed that the knife used was a completely different brand and style than those in the knife block.
Also, the formation of the handle would only have caused someone to hold it in a specific way.
And what does this suggest?
This suggests that Mr. Brackman would have been stabbed from behind, as that would completely match up with the stab wound. And this evidence was not a spontaneous attack, but was more in line with a premeditated murder.
I'd like to talk about the alleged scuffle in this crime scene. How does this connect to the crime?
While this mark could signify a struggle, you can't carbon date scuff marks to see how old they are. This mark could have been made years before the incident took place.
And did you notice anything else about the crime scene?
Yes, I noticed that there's a Ring camera Mr. Brackman owned.
And what did you conclude about this Ring camera?
While he did have a Ring camera, we don't know if he had notifications on or if the camera was set up at all. In addition to this, we don't even know Mr. Brackman had his phone on with him or was even paying attention to the notifications.
And in your expert opinion, what do you think happened on the day of Mr. Brackman's murder?
I believe Mr. Brackman was stabbed from behind while being seated with a knife the intruder had brought onto the scene. This indicates premeditation to commit murder and points away from Avery Becker as the most likely suspect.
And in your expert opinion on police practices, do you believe that the prosecution's police investigation was conducted properly?
Oh, absolutely not. This investigation was extremely mishandled.
Let's move on to other possibilities of the case. I'd like to direct your attention to what's previously been admitted as Exhibit 14. My co-counsel should be screen sharing that to you as well as the jury.
Sorry, I'm having a brief technical issue with the connection at our school.
If you would like, my technician can share it to the jury.
I just got it.
Okay.
Oh, God. Sorry.
That would be wonderful.
There we go. Exhibit 14.
Thank you.
Miss Medina, I think you might be frozen.
Oh. I'm so sorry, your audio is very sparkly. Could you repeat that?
I'm going to ask Ms. Humber to actually have her staff go ahead and share this exhibit so that we can continue sharing and hopefully keep connection.
Absolutely, we can have Miss Bennett Spurlock share that to the screen. And we can stop time as needed.
All right. Can everyone hear and see me clearly now?
Ms. Medina, unfortunately, you're very stuttery with your conversation. If you want to stop your video, I know it's a little bit unorthodox, but I'm just trying to get you as much connection as you can get. Are you able to still speak?
Thank you.
All right, could you please repeat the question?
Perfect. All right, Professor. All right, are we any better on the audio portion? I'm aware of what this exhibit is.
It's a little better. Try to speak a little more slowly. The connection for me is kind of speeding up.
Of course. Professor Van Owen, are you aware of what this exhibit is?
Yes, I am.
And what is it?
I'm so sorry. I cannot hear the question that you've just asked.
Ms. Medina, I'm going to recommend again that you go down to your microphone button, click that up arrow, caret, little guy thing, and reselect your microphone.
If that fails to work, I'd also recommend that we just not share the screen and share the screen constructively. Because sometimes sharing the screen can actually cause some pretty heavy bandwidth usage.
All right, Ms.
Is
Medina,
the
let's
audio
do a
working
test.
any better on mine?
Much better.
Oh, that is much better.
Oh, it is?
It is.
May
If
we
you'd like to
proceed?
continue.
Perfect, all right.
Yes.
Professor Van Owen, do you have a copy of Exhibit 14 in front of you?
Yes, I do.
And what are these?
These are the alleged text messages between Avery Becker and Alex Cifuentes.
And in your expert opinion, is obtaining screenshots of messages if the original phone was available at the time standard police practice?
No, I was shocked to find out that the prosecution had accepted the screenshots because most police departments have the technology to easily download content.
Objection outside of the scope.
Response?
Your Honor, this is within the scope of the witness's expertise under police investigation.
Overruled. Continue.
Professor Van Owen, in your investigation, did you find any other suspects for the murder?
I found several possibilities, but the one that stood out to me the most was Blair Rowlands.
And why did Blair Rowlands catch your attention?
A few months before Mr. Brackman's murder, Brackman had represented Jonathan Rowlands, Blair's father, because he'd been charged with murder.
And what happened to Jonathan Rowlands?
Well, Rowlands was convicted and sentenced to life in prison.
Did Jonathan Rowlands express any desire for revenge?
Yes, he did.
And how did you know that Jonathan wanted revenge?
I listened to a court proceeding from before Rowlands was sent to jail.
I'd now like to direct your attention to what has been marked as Exhibit 22. Do you recognize this?
Yes, I do.
And what is it?
It's an electronic recording from Jonathan Rowlands' court proceedings that I've listened to.
And is this a fair and as well as accurate representation of the proceeding?
Yes, it is.
My co-counsel should now be screen sharing that to you for identification. You're to move Exhibit 22 into evidence.
Any objection?
Yes, Your Honor. Hearsay. This is an out-of-court statement being offered for the truth of the matter asserted.
Unfortunately, I didn't hear the statement. I know it's only 5 seconds. If you wouldn't mind playing it again so I could try to hear it.
Yes, of course.
Of course.
I'll get you back, Brackman, if it's the last thing I do.
Very dramatic. Any response?
May I respond, Your Honor? Yes. Under Rule 8033, this is a statement of the declarant's state of mind as well as a motive to seek revenge against Mackenzie Brackman.
I'm going to overrule the objection and allow the admission of this item.
Thank you. Professor Van Owen, what did we just hear?
Oh, this is Jonathan Rowlands at his trial.
And how do you know that this was Jonathan Rowlands?
Because I had listened to the entire case and I'd heard Jonathan Rowlands identify himself.
And what did this recording tell you?
Well, this recording shows that Rowlands had expressed his desire for revenge.
And how would this have affected Blair, his child?
Well, Blair was in the courtroom at this time, meaning they would have heard their father's wish.
And how do you know that Blair was in the room?
They spoke on behalf of their father in an earlier portion of the recording.
Objection, hearsay.
Response?
Your Honor, this is not being offered for the truth of the matter. This is merely to establish as well as lay foundation to the fact that Blair Rowlands was in the same courtroom.
Response, Ms. Humber?
Your Honor, this is being offered for the truth of the matter asserted, as Blair Rowlands' testimony was being offered to show her history of animosity between her and the victim in this case.
Any last response?
Yes, Your Honor. This is not an out-of-court statement being made for the truth of the matter. There is no statement being brought in the witness's testimony that has not been made inside the courtroom. This is merely the witness providing information in her affidavit of knowledge that Blair Rowlands was in the courtroom.
I'm going to sustain the objection. I think there's other ways to testify to that effect.
Professor Van Owen, what observations did you make about Blair Rowlands?
Oh, well, Blair Rollins was missing from school at the same time of the murder. They also matched the build of the intruder and have a possible motive to kill Brackman.
And do you think that this possibility should have affected the prosecution's investigation?
Well, I think this was something worth knowing to bring Mr. Brackman to justice, but unfortunately, the prosecution had mailed to fake an investigation of this possibility.
Thank you. Your Honor, I have no further questions at this time.
Any cross-examination?
Yes, Your Honor.
You may begin.
Good evening, Ms. Van Owen. I'd like to start by clarifying something you said in your direct. So you talked about Exhibit 22, wherein Jonathan Rollins, someone in prison, states, "I'll get back at you, Brackman, if it's the last thing I do."
Yes, his declaration for revenge.
Thank you. And you heard Avery Becker testify today, the defendant?
Yes, I did.
And you heard her admit that she said to her mom, "I'll get back at Mr. Brackman if it's the last thing I do."
Well, she was very upset, so it can be understandable why she would have said that.
That wasn't quite my question. Did she say this, admit to saying this statement?
Like I just said, yes, she did.
Thank you. I'd like to talk about your history in this line of work. You formerly worked at the police department?
Yes, I have.
And in the mere 9 months you worked for the PD, you were sued for assault.
Yes, I was disillusioned with police office work.
You were sued for assault.
It was an incident. I learned my lesson. The assaultee.
You were sued for assault.
If I may respond, yes, I did. And that was a very unfortunate event. I learned from my actions, and the person who had sued me had won, had gotten her money, and I was fired immediately. And it helped me to learn and grow as a person. And I've never done anything such since.
Okay, and today you are testifying against police officers after having left the PD.
After seeing how corrupt it was, yes.
You left the police department with a chip on your shoulder, and now you testify against police officers.
Objection, Your Honor. Improper character evidence.
Response?
Your Honor, this is not being offered to show the character of Professor Van Owen. Rather, I'm laying foundation as to any bias between her and the police in today's case. It is very relevant to her ability to testify credibly.
I'm going to sustain the objection and ask you to rephrase.
Yes, Your Honor, I can gladly move on. I'd like to transition to your payment for today's case. So you're being paid $225 per hour for investigation work.
Yes, I do expect to be paid for my efforts.
You charge $450 per hour for in-court testimony.
I do expect to be paid for my expert witness statement and doing extra work I wasn't supposed to, like doing investigations for the prosecution when should have been done in the first place.
Your payments double from $225 to $450 just by stepping in a courtroom.
As I've said, I've done a lot of extra work I haven't had to, and like some of the other lawyers here, I do expect to be paid for my efforts. This is my job.
And your payment doubles in a courtroom. Is that because in a courtroom, you are under penalty of perjury?
No.
You don't think that in a courtroom you are under penalty of perjury?
I'm sorry, you broke up. Can you please repeat that?
You don't think that in a courtroom you are under penalty of perjury?
Objection, Your Honor. Assuming facts not in evidence, this has nothing to do with the witness's affidavit nor the information they are testifying about today.
Overruled. The witness opened the door.
All right, could you please rephrase the question real quick?
Because you are in a courtroom, you are under oath today and under penalty of perjury.
Yes.
Thank you, Professor. Let's talk a little more about the work you're actually getting paid for. You've consulted for over 100 cases?
Yes, I have. I'm very qualified.
And on estimate, how many of those have been for the defense?
I have a reason for always representing the defense. I've seen how corrupt the system can be, and the defense doesn't always get as much as the prosecution.
So how many of those have been for the defense on estimate? All of them?
Almost.
Thank you. With that, let's talk about the facts at hand. You disagree with the prosecution's theory that there was a struggle during the crime.
I do.
You believe that ring alerts and scuff marks are unreliable indicators of a brawl.
Well, they don't match up as well with the evidence, so.
Now it is your job to analyze the police evidence for the defense, correct?
That is correct, yes.
And you heard both experts testify to a broken plate on the scene?
Yes, that broken plate could have happened during the struggle when Brackman stood up, when he was being stabbed.
You heard both experts testify to the plate?
Yes, and the breaking of the plate could have happened while he was being stabbed.
So the broken plate on the floor of a crime scene is left out entirely from your report?
Well, it could be marked off, seeing as it was right next to the table and could have easily just been knocked over and broken.
It is not in your report. No.
Out of all the important things, I did not think a broken plate was the most important to acknowledge.
Thank you, Professor. I'd like to transition to a different aspect of your story, specifically the alibi. It is your belief that the defendant and Taylor were out looking for a phone?
Yes, it is.
And cell tower records of Taylor Perkins' phone could confirm this supposed theory?
Yes, they can.
You heard Taylor Perkins testify today that he may be willing to lie for the defendant?
Well, they're best friends, so that is understandable, yes.
You had the ability to obtain these records of Taylor's phone?
I'm not with the police, so I cannot go into a phone without a warrant.
Is that your statement today, that you did not have the ability to obtain the records of Taylor's phone?
First of all, that wasn't my job. I'm not part of the prosecution. That was the prosecution's job. It's not my fault it was done sloppily. Also, I am not part of the police force. It might have been illegal for me to have gone into someone's phone.
You had the ability to obtain the records of Taylor's phone, as stated in your affidavit today?
I had some ability, yes.
Yet you didn't bother to present this evidence on behalf of a defense witness to the jury.
Yes.
Interesting. While we're on this topic, let's talk more about the cell tower records you did decide to look at. Could I direct you to Exhibit 16 if you have a copy in front of you?
You may.
All right. Now, you stated that these records are inconclusive of the defendant's phone's location?
Yes, cell tower phone data can be very, very unreliable sometimes.
Something like a jump from tower to tower?
Yes, cell towers work strange and not the closest one, but the one with the strongest connection. So sometimes it's reliable, sometimes it isn't.
Okay, if you could confirm with a yes after each statement, I'm going to read the time and location of each record on this map. 1247, cell tower near the defendant's house.
Yes, I believe that's.
1255, cell tower near a major intersection.
Yes.
105, 106, and 117. Cell tower near Mackenzie Brackman's house.
Yes, makes sense, seeing as it was near a major intersection.
It was near Mackenzie Brackman's house?
Yes, cell phone tower data could have ended up there. Could have happened.
Were all of those times in chronological order?
I believe so.
And Professor Van Owen, you believe this chronology is due to coincidence alone?
Like I said, cell phone tower data can be very shifty and cannot always be the most reliable. So I do not think we should base things directly on that.
Is that a yes? This is due to coincidence in chronology of time?
Yes, it could be due to coincidence.
Thank you, Professor Van Owen. Your Honor, no further questions at this time.
Any redirect?
Yes, Your Honor, brief redirect. Before we begin, may I have a quick time check?
4 minutes and 4 seconds remaining.
Thank you. Professor Van Owen, were you required to conduct your own investigation?
No, I was not. However, I thought it was necessary because of how poorly it was handled.
And do you believe that the evidence provided to you by the prosecution was sufficient to conduct your review in high standards?
Absolutely not. The prosecution should have done much more to come to a concrete conclusion.
Thank you. Your Honor, I have no further questions, and at this time, the defense rests their case.
Very well. Any motions prior to closing?
No, Your Honor. None from the defense.
In that case, we will go ahead and begin with the prosecution might like to make a closing statement.
Yes, Your Honor.
All right, you may begin.
Mischief was intended. In murder, it ended. Members of the jury, allow me to take you back to a scene that my co-counsel, Miss May, mentioned in her opening. It's 3 o'clock on a Thursday, and Avery Becker furiously storms into the kitchen. See, despite being an expert in swaying the jury, her mock trial coach has ridiculed her efforts. Coach Brackman's criticisms have gotten worse, and she's had enough. After Coach Brackman demoted and removed the defendant from the team, she boiled in rage, climbed to the top of his car, and wrote in bold permanent marker across the hood, "Worst Attorney Award." But to her, this wasn't enough. As she hides away the Sharpie, the defendant texts her friend Alex, telling her plan to break in to Brackman's house and once again vandalize his belongings. Her eyes are tearful with anger. The defendant's mom enters the kitchen to ask what's wrong, to which the defendant responds, "I'll get back at him if it's the last thing I do." Today, the prosecution has proven beyond a reasonable doubt that the defendant committed second-degree burglary and first-degree murder. We have proven that the defendant knowingly and unlawfully entered the dwelling of Mackenzie Brackman with intent to commit criminal mischief. And while in this dwelling, the evidence proves the defendant, during a burglary, caused the death of Mackenzie Brackman. To break that down, mischief was intended, in murder it ended. The prosecution holds the burden of proving the defendant guilty beyond a reasonable doubt. Please remember that reasonable doubt is not beyond any possible or speculative doubt. Reasonable doubt must be based on the cumulative evidence presented. Looking at this case as a whole, the prosecution has left no reasonable doubt. The defendant demonstrated intent to break into Mackenzie Brackman's house. Alex C. Fuentes read the vengeful text wherein the defendant states, "I'm going to wait until he's at work, then break in and trash his house." That'll show him. Less than 24 hours later, a person masked and gloved with the same height and build as the defendant is seen at Brackman's house. Detective Kyle Kuzak presented video evidence of this intruder as she is seen breaking in through the back door, just as the defendant said she would. Upon entering, the defendant came face to face with Mackenzie Brackman. A confrontation ensued. Brackman was stabbed and the defendant fled the scene. Detective Jordan Markowitz testified to evidence of the struggle firsthand: a broken plate, a flipped chair, and Mackenzie Brackman dead on the floor in his own blood from a fatal stab wound. During this time, Alex sat in class, Avery's empty seat beside her, and wondered why she wasn't in school that day. But members of the jury, you know where she was. Detective Markowitz testified to cell tower records placing the defendant's phone at Mackenzie Brackman's house the same day of the murder. She drew a clear line of that path. I challenge opposing counsel to answer the question, where is the defense's line? What is their common thread? The prosecution has proven their answer to be quite simple. They don't have one. Today, we look back at Avery Becker in the kitchen, fired up after vandalizing Coach's car and planning her next move. But this time, her attack is more permanent than a Sharpie. Mischief was intended and murder ended. Members of the jury, the defendant, while unlawfully entering Mackenzie Brackman's home, caused the death of Mackenzie Brackman. Find her guilty. Thank you.
Would the defense like to make a closing statement?
Yes, Your Honor.
You may proceed.
All right, sorry. Before I begin, I would like to clarify that the court can see and hear me correctly.
We can.
All right. Members of the jury, you are here today to decide the fate of Avery Becker. The prosecution would like you to believe that they have proven, beyond a reasonable doubt, that she is guilty. They have not done this. Throughout the course of this trial, we have proven that their investigation was sloppy, their evidence selective, and their case circumstantial. You heard from Detective Markowitz and Kyle Cusack, who came to their conclusion that Avery Becker did in fact kill Mackenzie Brackman using limited evidence and sloppy technique. By all accounts, they seem to have decided that Miss Becker was the culprit before ever looking into evidence for her guilt. If they hadn't, they would have seen that other avenues should have been explored. They conducted an investigation that relied on a lost phone in the vague area of Mr. Brackman's house and on texts that could have easily been doctored. In addition, much of their other evidence of the scene was irreparably damaged, casting further doubt on the investigation. To see just how mishandled this case was, one must look no further than the suspect never investigated. Blair Rollins, a student with a grudge against Coach Brackman for putting her father in prison for life, who just so happens to be of the same height and build as Avery Becker, who was not at the scene on the day, who was not at school on the day of the crime, who would have taken the same route as Avery Becker to get to Mr. Brackman's house, and who has since disappeared. However, the prosecution decided not to investigate this possibility, which isn't only worrying, but cast doubt on the entire investigation. If they simply ignored the indications pointing towards Rollins, what else could they have missed? You then heard from expert witness Blake Van Owen, who further highlighted the rushed nature of the police's investigation and the flawed logic in the reconstruction of the scene. Her appraisal of the knife used to murder Mr. Brackman and of the alleged scuffle at the crime scene only cement the impression of a case that missed critical facets. She reminds us that the evidence doesn't point to anyone concretely, let alone the defendant. You then heard from Avery Becker herself and her best friend, Taylor Perkins. They let us in on what the prosecution is trying to claim to be the motive. The petty drama of a high school club. Well, Miss Becker and Mr. Brackman didn't always see eye to eye. The leap from frustrations to burglary and murder is a hard one to make. They also recount the details of where they were that day. Looking for a lost phone, a story that is soundly supported by the cell data records produced by the prosecution's own Detective Markowitz. Their testimony only proves what the prosecution should have known all along. Avery's alibi is solid. Her motive is questionable at best, and the only evidence linking her to the scene of the crime is a video of somebody with a vaguely similar height and build, a lost phone in the general area of the scene of the crime, and texts that nobody other than Alex Cifuentes, who never liked Avery, has ever seen. But then the question becomes, how did Mr. Brackman die? Could it have been at the hands of Blair Rollins' revenge for father's life sentence? We don't know. Could it have been a setup by Alex Cifuentes to get rid of a longtime rival? We don't know. Could it have just been a tragic accident, the result of a random home invasion gone wrong? We don't know. And there is a reason for that. Because this case was gravely mishandled, the blame for this crime is being laid on the wrong person, and true justice may never be found. The prosecution must prove, beyond a reasonable doubt, that Avery Becker killed Mackenzie Brackman. They have not done this. The case for Avery's guilt is circumstantial. The evidence for Avery's guilt is selective, and the investigation into it was sloppy and rushed. For a conviction, the questions of Blair Rollins and Alex Cifuentes, of the lost texts and the missing phone, must be answered. In failing to do so, the prosecution has also failed to meet the burden of beyond a reasonable doubt. The only thing more tragic than the death of Mackenzie Brackman would be to put one of his own students in prison for a crime that she didn't commit. And for that reason, we ask you to declare the defendant, Avery Becker, not guilty.
Thank you for your time today.
Does the prosecution wish to make a rebuttal?
Yes, Your Honor. May I request a brief time check before beginning?
58 seconds remain.
Thank you, Ms. Bennett-Spurlock. May I proceed?
Yes, briefly.
Ms. Farrell mentioned a solid alibi, but let's talk about that alibi. This is from someone, Taylor Perkins, who would, quote, lie for his best friend. The defense also attempts to offer Blair Rollins as a suspect in this case. Let me remind you that the burden of proof and the jury instructions implore you to look at all the evidence as a whole. Blair Rollins has no criminal history or history of animosity between the victim. But the defendant not only has a history of acting against the victim, but a history of acting with animosity as shown through years of mock trial practice. Mischief was intended, in murder it ended. Find the defendant guilty. Thank you.
I'd like to thank everybody for participating in the trial today. Obviously, these things are wildly scary and exciting. I'm going to ask that you give us just a couple minutes to submit our scores, and then we'll chat with you just after that.
I'd like to request the scorekeepers, once you've submitted your score sheets, please turn your cameras on. Okay, well, our scoring panelist has not turned on their video, but I have been given the confirmation that all of our scoring sheets have been submitted.
I can't
so
turn my camera on. I'm
Okay.
interrupt. I was
Not
trying-
it's probably because I turned it off. Oh,
yeah,
let me
says
turn it
you
on for
turned
you.
it off. It won't let me. There we
Judge,
go.
you're more than welcome to move
There we
ahead
are.
with feedback. Thank you, Alessandra.
Sorry about that.
So like I said, I always appreciate that everybody shows up for these things, and more importantly, just gets engaged in trial advocacy. It's one of the most important things that basically every attorney that I work with says. As I mentioned, I've been an attorney now. I've been an attorney in the criminal defense field for about 15 years. I specialize in mostly felony defense cases, serious things. Try to stay away from murder just because it takes too much time, but hey, we can't be perfect. So I kind of want to go over a few quick comments for each of the teams, and I'm going to try to keep this as brief as possible because I know that you have a lot coming up and a lot to prepare for. First, don't let it get you down if technology fails. Technology fails all the time. I was in court the other day and my internet went out the whole house. Great. You just have to make it work. And I think you all handled it wonderfully. And you really did your best to really go above and beyond even when technology fails. The internet is not perfect. It will fail. So don't let it get you down if the internet gets you. So first off, I'll start with, let's see. Elena, I'm going to pick on you first. You were very well poised. I loved how you presented yourself. You always seemed like you knew what you were going for. You had a really good cross on the lost text messages. which I thought was great. Everybody kind of left that wondering, saying, so there's lost text messages. Where did they come from? Is this really unedited? Are they edited? We don't know. Emma, your response to objections were perfect. And I really think that that's an important thing to say, okay? Because when you get into these objections, it's a very tough thing to have people come to you and say these horrible things. And when the specific one that I remember was when you had the picture of the dead body and you said, this is difficult to look at, but this is a murder case. That was exactly right, okay? That overcomes the prejudice in there because there is a lot of probative value. Let's see. Trying to find everybody's picture here. So Leah, you had also very well crafted objections. You clearly know the case extremely well. I do have to mention this to you, and I think this applies to a lot of people. When we come into something, sometimes the defense's entire purpose is to throw a wrench in the prosecution's case. And when you were talking about, so you didn't have the opportunity to go out, and you could have gotten it from this other person, but you didn't. And the witness then turned around and said, that's not in my statement. You're asking a hypothetical. It doesn't have to be in the statement. Push the issue, okay? Because the fact is, your question, your hypothetical there was great. You had the opportunity, but you didn't. And they say, well, no, it's not in there, so I didn't. Great. Don't give up on objections. If you were objected to, it's not the end of that question. You don't have to say move on. A lot of times the judge or something will give you a hint. Like I may say, I'll sustain that objection, please rephrase. That doesn't mean move on. That means literally just rephrase it, maybe without the antagonistic term within that question. Lily, I loved what you did, so you were sued for assault, and you deadpanned it for the next 5 times that you asked the exact same question, which was the right thing to do. It really just got past the witness trying to evade the answer and really kept hammering that into the jury, where that might not have gone otherwise. It might have been overlooked. But because you got to ask that question over and over again, the jury's not listening to the witness try to evade, they're listening to your question. And that's one of the things that when I was taught trial practice was a very important compliment, is that if you get the jury listening not to the answers that the witness is giving, but to what questions you're asking, you're testifying. And it's beautiful when you can do that. So just keep that in mind. I think everybody really needs to focus on the fact that you cannot, or you need to be very careful about asking for conclusions from witnesses, the gotcha moment. But you said this, were you lying then or were you lying now? That's a great option. And Alexandra, I know that you kind of got into those things a little bit, but you have to be careful about using that. Speaking of Alexandra, I loved your passion. It really shows that you got into it. And more importantly, you got really inflamed when you were cross-examining people. And that can show a lot because it draws the attention to your questions. And especially on cross, that's very important because you can show what you need out of it by ignoring what they are really saying. So those were really my comments. I'm going to go ahead and post my email address in the chat. You're all welcome to reach out through your coach or reach out directly. I'll be happy to give additional commentary, but otherwise, any of the other ruling or scoring judges wish to make any comments?
I just want to say you guys did fantastic. This was extremely difficult to judge. Close, very close competition. Both teams did tremendous. You guys should be very proud of yourselves. Any one of you who has the dream to really pursue this, do it. Don't let anything stop you. You guys are awesome. You give me flashbacks to when I was on my high school mock trial team, and you guys are all better than I ever was. So, you know, keep it up and keep on keeping on. And you guys rocked. Just keep doing well. And, you know, be well to each other. One of you guys offered to show an exhibit to for the other team when they were having technical difficulty. I think that was you, Lily. Extremely kind of you to do that. That's the type of sportsmanship you should carry throughout. Every one of you were excellent in your own way, and it was awesome to watch this. Thank you guys for letting me be part of it.
And I would just echo that. You were all extremely well prepared. Your witnesses actually played the roles within of what we would expect from that witness, whether it was a high school student or it was a professional. I think they stuck true to form on what the roles were. You handled some difficult things extremely well. I mean, some of you had very tricky witnesses to cross-examine, and you did a fabulous job with that particular task. And that's not always easy. And Chris had mentioned, don't give up on your objection. I would like to echo that. Sometimes you might draw an objection and just a little tweak of your question, you're going to get it in. So don't feel like you have to give up and move on. Keep up the battle, at least maybe for one more good question, and give it a try. But you all did a fantastic job. You should be really proud of yourselves. Great work.
And my name is Doug Stevens, and I'm a civil litigation attorney at Kaplan and Ernest in Boulder. I've been practicing for, coming up on 20 years now, which I find hard to believe. Overall, I echo what everyone else said. Wonderful job with all around. I mean, the openings, the closings, no notes at all. That was great. Great use of the hand gestures. Wonderful use of the themes. Mischief was intended and murder it ended. That was really good. I thought both of you on the closing were great. With the prosecution, great job weaving the themes in, explaining the legal burdens, kind of weaving the facts into the theme and law. Good job on the rebuttal and closing. On the defense side, great job pounding that high burden of beyond a reasonable doubt, and raising, as Chris indicated, raising other possibilities, other possible scenarios as to what may have explained the commission of the murder. So I thought those were excellent job, and it's not easy looking at a computer screen. It's a lot easier looking at a jury, and you right in that room with them, and you could feed off of what they're saying. With the witnesses, I thought you all did a really good job, very believable. The experts, and this is a technical subject matter, did a great, believable job in discussing the evidence. One comment, as an expert, try to keep the emotions out. As a lay witness, as a fact witness, if it's your best friend murdered or your best friend's a defendant, totally understandable, you may have emotion. As an expert, you don't want to show emotion. You want to be the credible, professorial, expert, objective. You're not biased. So try to keep that in mind. Great job with the voir dire of the witness on, I forgot which witness it was, but really good job. The objections in general were wonderful. Great command of the rules of evidence. And as everyone else is saying, fight back. If you're asking those questions and you draw an objection, just, fight for trying to get that evidence in, because that could be key evidence for you. I thought it was a good job on cross on several occasions, accentuating certain words and really focusing, bringing out what's really important, and showing the passion into the case. Great job on the cross. I think it was of Professor Van Owen on demonstrating the bias of that expert. I thought that was a really good job. On a couple of occasions in general, try not to be, overall, I don't think this was really an issue, but on a couple of occasions, if you get some gem in your examination, ask that follow-up to try not to be wedded to your notes. It's hard. It's a very hard thing to do, but sometimes you'll get some good gems. So just be prepared to pounce all over that rather than just moving on. But overall, I thought you all did a wonderful job, and congratulations to all of you. You all have a definite future in the law if you want it.
I just have to give a special point out and call out to Ms. Humber. Getting the 56 seconds timekeeping and just being able to pull that together, that's impressive. That was awesome. It gave me a good laugh.
And you didn't come across as frazzled either. It's very easy rebuttal and closing to come across as frazzled when you have under a minute and you have all this stuff. So I thought you just really tied it up nicely.
Otherwise, like I said, you're free to reach out once everything's ended here, but good luck with the rest of the competition. I think that ends it for this evening.
Thank you all so much.
Thank
Thank you guys so much.
Thank you, everyone.
Good luck with the rest of the competition.
Bye-bye.